Hello, students. I'm back with another video lecture, continuing Unit 3, Authority to Detain and Arrest, Use of Force. We're in Week 6 with law enforcement contacts, and this video lecture is about detentions. Um, so I want to talk to you first about a well-known case called Terry versus Ohio. It should be in your book. Terry versus Ohio is the case by the U.S. Supreme Court where they created this intermediate type of contact that we call a detention. It's also called a Terry stop or an investigative stop. I prefer detention, but Terry versus Ohio is the case where the U.S. Supreme Court created it. That's why it's so important. In Terry versus Ohio, you had a police officer 30 years or so experience as a police officer detective, and he was watching Officer McFadden was watching Terry and a group of other men. They were standing on the corner as a business district, and each man uh, walked down the sidewalk, stopped in front of a store, looked into the store, continued past the store, turned around, walked back to the store, looked into the store, and then joined the men on the corner. And a couple of these guys did that. And McFadden, who had all this experience, formed an opinion that these men were casing this store to commit an armed robbery. So, based on his observations and his expert opinion that they were casing the store to commit an armed robbery, he confronted them and contacted them, and he ended up pushing Terry up against the wall, and he patted Terry down, felt an object, and removed it, which was a handgun. So Terry gets charged not with any, he wasn't charged with a robbery or attempted robbery, he's charged with a handgun violation. He made a motion to suppress, and the court upheld the pat down. They upheld the contact and upheld the pat down of his outer clothing um, to check for a weapon, and denied his motion to suppress. He was convicted, which led to the appeal. Anyway, so Terry versus Ohio is the case that created this um, intermediate contact that we call a detention. Prior to Terry, there was only a consensual encounter and arrest. There did not exist this intermediate ground. So that's why Terry was so important in this area. So a detention, remember, is a seizure. And just as a reminder, when is a person seized? A person is seized when they submit to lawful authority of a police officer, and usually that's done when a police officer makes a command: come here, sit down, don't move, hands up, things like that. It's a command. It's not a request. They're not asking. They are making a command, and the person submits to it. Or the other way a person is seized, it occurs when the officer used physical force. So you have a seizure, and once you have a seizure, it has to be justified under the Fourth Amendment. The law is going to classify the seizure as either this detention that I'm talking about or an arrest, which I'll talk to you about later. So what's a legal standard to make a detention? A legal standard is reasonable suspicion. It's a reasonable suspicion standard. It's not 100% certainty. It's not absolute. It's suspicion, reasonable suspicion that the person is involved in criminal activity. Now, that criminal activity could be activity that happened in the past, or it's occurring right now, such as McFadden, or uh, will occur in the future. But the person is connected to this criminal activity. The purpose of the detention then, remember, you're detaining the person because you have suspicion that the person is involved in criminal activity, but you don't really know. So this type of contact allows the officer who has suspicion of criminal activity to check it out. Is the person involved in criminal activity or not involved in criminal activity? The reasonable suspicion has to be based on facts. It cannot be based on your gut feeling, a hunch. You have to be able, if you're the officer, to articulate the facts that give rise to this level of suspicion. So you have to have facts, and you have to know these facts before you make the seizure. You cannot make the seizure, you cannot detain a person or arrest a person, then justify it after you do it. You have to know these things before you do it. That's an important thing. So the purpose of the detention is to either eliminate your suspicion. So you eliminate the suspicion, you find out that the person is not involved in criminal activity. So what do you do if you're the officer? You let the person go. You explain to them, well, I suspected this. I know you're not involved in it, so you're free to go. On the other hand, the other idea behind this contact is to either eliminate it or to confirm it. If you confirm it, you're going to take the next step, which is usually an arrest because you confirm the suspicion and now you have probable cause to believe the person committed a crime. You're going to arrest that person for that crime. So the purpose is to eliminate your suspicion or to confirm the suspicion. Now, there are a couple rules that come into play. One is that you have to act expeditiously. That means you have to act as quickly as possible to confirm or eliminate the suspicion. You cannot dilly-dally around. You have to do it as quickly as possible. There is no really set time. Every case is different. It's on a case-by-case determination, but there's cases that suggest that 90 minutes is the longest. So you have to act expeditiously. There's a case in the book and it involved a lady who, or a man that was actually suspected of bringing drugs through an airport. And the police had information that he was doing that. They contacted him. They asked him if he would accompany him to their office so they can further their investigation. He refused. He's not going to do that. He wasn't like Dumb and Dumber. He said, no, I'm not going to do that. But the officers decided to, based on the information they had, to detain the bag for further investigation. So this seizure can involve not only people, but it can also involve objects. So they detained the bag. They wanted to do further investigation, and they decided that they were going to call out a canine to sniff the bag to determine if the bag held contraband. So this was on a Friday. The dog, and this happened at an airport in New York, and I believe they were at like JFK. The dog was at LaGuardia, so they summoned the dog. Well, it took hours for this dog to get there, but when the dog finally got there, the dog alerted on the bag. So that gave them probable cause to believe that the bag contained contraband. So the next step is to search the bag. Well, they chose to seek a search warrant, which is what they should do. So they wrote the search warrant, but the trouble was this was Friday, it was very late, it was after 5, after business hours, and they had to locate a judge. Well, they weren't able to locate a judge until Monday. So Monday they get the search warrant, they search the bag, they find contraband. The person's charged, he makes a motion to suppress. And the court held about a detention in this case that they detained that they did not act expeditiously. That was the problem. They took too long to do their investigation. They detained that bag too long. They determined that this seizure was actually akin or equivalent to an arrest, which required probable cause. They did not have probable cause, so the court suppressed the evidence. So you have to act expeditiously as quickly as possible. In that case I just told you about, the officers should have planned ahead of time. They could have had the dog right there at the airport waiting for this guy, and the dog could have sniffed immediately, and they could have had probable cause. They could have also given a heads up to the judge to do what? That they were going to need him to sign a warrant and find out where the judge would be and make those arrangements ahead of time. There's also another thing they could have done is that is um, written a search warrant ahead of time, and it's called an anticipatory search warrant. And if certain things occur, then they have the authority under the warrant to go ahead and search the bag. So they could have had all of that set up. They could have had this done, wrapped up in probably a few minutes, honestly. But they didn't. They were not thinking. They didn't. They didn't take a class apparently to learn how to do those things. So unfortunately, you know, on behalf of police, unfortunately, the evidence was suppressed. Fortunately for this person, it was suppressed and he was able to have the charges dismissed. So, anyway, that's the rule. You have to act expeditiously. Um, the other thing, the other rule actually is you have to use the least intrusive means to confirm or eliminate the suspicion. So you can do different things. You can talk to others. You can use your dispatcher or other officers. You can check warrants. You can do a infield show up, which we'll talk about in another class. But you have to use the least intrusive means to do it. I'll give you an example of my own. When I was on patrol, this is a long time ago. I was working graveyards and I pulled up behind a car at an intersection. Is a big old car, big old trunk, and I could see the trunk was propped open. And inside of the trunk, I could see a motorcycle. And I think that it's kind of unusual at 3 o'clock in the morning to see a big car with carrying a motorcycle in the trunk. So anyway, I ended up stopping that car. Um, And then I contacted the driver, and of course, I asked him about the motorcycle, and he said he borrowed it from his friend. I said, "Well, what's the name of your friend?" I don't know. Okay. Where does your friend live? I don't know that either. So I needed to what? My suspicion was that this was a stolen motorcycle, so I needed to either confirm it or eliminate my suspicion. I had to do that expeditiously and use the least intrusive means. So I looked for a license plate. There was no plate on it, but you know that vehicles have a vehicle identification number or VIN. So I ran the VIN through our dispatcher. They came back with it was not stolen, but they also had the registered owner of the vehicle on file. So I asked my dispatcher contact the registered owner and find out about his motorcycle. So they did, and the registered owner confirmed that his motorcycle was missing from his parking stall, and that these people did not have permission to possess or take it, and further that it was there when he went to bed just a few hours, you know, prior to my stopping these individuals. So what did I do? I used it very expeditiously, didn't take long, took running a running the VIN and making phone contact through our dispatcher. So that was very quickly. It was very not very intrusive. And what did I do? I confirmed my suspicion. When I confirmed my suspicion, I had probable cause to arrest the individuals in the vehicle for the theft of the motorcycle or possession of the stolen motorcycle, which I did. So that's just an example of how that works. Another example would be the theft or robbery at one of these stop and go type markets, right? We have a lot of beer runs, so there's a beer run at a stop and go. The suspects leave. The clerk gets on the phone and calls the police, and the dispatcher gets a description, and they broadcast that description out to the officers that are responding to this robbery, right, or this theft. So they have a description now. Some officers or an officer might go to the scene to contact the victim, the clerk, and other officers are searching the surrounding area. So let's say they have a description of this person and they're on I don't know, 10-speed purple bike, and they're wearing a San Francisco 49ers jersey, and they have some sort of hat on, right? So an officer sees a person on a mountain type bike with that kind of jersey and a hat on, and they're huffing and puffing, riding fast as they can away from the store. Does that does that give them, based on all these facts that I've just disclosed, reasonable suspicion to stop them? I say it does. So they stop that person. They say, "Hey, stop." And the person submits, or they have to use force, but they seize them, they stop them, they have a detention. They have suspicion that this person is involved in this theft or robbery. So now they have to do what? They have to eliminate or confirm that suspicion. They have to do it expeditiously in the least intrusive method to do that, right? So what are they going to do? Well, the best way would be to do what? They could have the clerk come to the scene. That's called an in-field show up, to look at the person and say, yes, that's the person, or not, that isn't the person. So let's say they do that, and they say, the clerk says, well, that's not the person. Well, the officer just eliminated the suspicion. They're going to let that person go. But if the clerk says, yeah, that's the guy, they just confirm the suspicion. Now what do you have? You have probable cause to arrest, and you arrest. That's just one way to do it. But there's other ways now, because you could take a quick photograph of the person that you have detained. You could send it to the officer at the scene, or um, that's probably a quick way to do it. Or actually, you could have an officer that's at the scene look at, if there's a video camera, look at the video feed from the store, and then drive out to where the person is detained to see if they match. So there's different ways to do it. But the point is, I think you understand the point, is that you have to have the suspicion. You want to confirm or eliminate it. You do it expeditiously in the least intrusive means to do it. Because if you don't, you're going to run into the problem that the New York cops had when they kept that bag too long before they got the warrant, and that led to the suppression of the evidence in the bag, right? So that's important. Um, what can you do during a detention to secure your safety if you're the police officer? So it's really a two-step process. The second step is this. If you have you have to have additional reasonable suspicion to believe that this person is armed or dangerous, then you can do a pat down, similar to the pat down in Terry versus Ohio. You can pat down the outer clothing for a weapon. So you have suspicion to believe that this guy is armed, right? And you have to confirm or eliminate the suspicion. The way you do that is by patting the person down. You're not searching, you're not going into pockets. That would be a full-blown search. You're just patting the person down, outer clothing. Officers are taught how to do that. There's a certain way that they're taught. They're taught how to do that. Now, if the officer during the pat down feels a weapon, the officer should immediately take it. You don't ask the guy to give it to you. No, that's dangerous. You take the weapon, you render it safe. Either you put it in your pocket, your belt, you give it to another officer, you render it safe. Now, if you pat down a person and there's no weapons, well, good, you're good to go. You can go on and do your investigation to confirm or eliminate your suspicion. What happens though if the officer's patting a person down and they feel an object? And if they feel this object and it's immediately apparent to them it's contraband based on their prior education, training, and experience, they know this is contraband. They have felt this before. They know exactly what it is. They know it as soon as they touched it. Then that gives them probable cause right then and there to go into that pocket and to take that item out, and to if it is contraband, what's going to happen? That's going to give them probable cause to make the arrest. On the other hand, if they're patting a person down, they touch an object, they know it's not a weapon, right? Can they take it if they know it's not a weapon? That's the issue. So they can't tell what it is. They know it's not a weapon, and they know it's not contraband. They don't know what it is. Can they manipulate that item with their fingers to figure out what it is? They can't do that. That's a search. And then, even though you're outer clothing, you're manipulating an object that's inside. that pocket with your fingers to determine what it is, that's considered to be a search and that would require probable cause. So you cannot do that. Um, so those are the rules for detention. It's that intermediate level of contact. It's less than arrest, more than a consensual encounter. It was created by Terry versus Ohio. It's very important. I'm telling you, it's very important that officers understand these rules and do it correctly. Now, when I was a judge in the criminal department, I had a motion to suppress, and the officers stopped and patted down this individual, and I don't know, they found something on him. I think it was a gun, actually. And there was a motion to suppress, and the officer was, he testified, well, we stopped the car, the guy got out, and I patted him down, I found the gun, right? Well, the officer was asked, well, why did you pat him down? And the officer says, well, it's standard operating procedure to pat him down. So what do you think about that? Is that sufficient to do a pat down? The answer is no. No, the officer did not articulate any facts giving him suspicion that the person was armed and dangerous. He just said that's their standard procedure. Well, standard procedure is not enough. It was insufficient. So I granted the motion to suppress. The gun was suppressed. That charge was had to be dismissed. I don't remember if there's other evidence that they could go forward against this person with, but the gun was gone, so the charge was dismissed. So the officers have to understand this. Officers have to know it and um, be able to do this correctly. Not only do it correctly, they need to write this in the report and then they need to testify about it. Because again, remember, if they're acting without a warrant, then that search or seizure is presumed to be unlawful, and the burden's going to be on the people to prove that there was an exception, they did this correctly. And that means the officer will be called to the stand to testify and justify what he or she did. So I hope this clarifies that and helps you understand it. And I'll be posting some more video lectures, but until then, stay safe. Take care.